Judge Randolph, any response, quickly?
We'll take questions.
Quick questions. Okay, we'll go right to questions. Over here.
Thank you. Thank you again, panelists, for providing a fascinating discussion. This is a question primarily for Professor Graglia, and I hope I pronounced your name properly. Most of us here, by virtue of being here, are probably libertarians or conservatives of some persuasion. And so it strikes me as a little bit ironic that we all here don't really trust the government, and so we like the Constitution as a protection against the government's overreach, but we get nervous when the court's interpretation of the Constitution strays a little bit too far from what we believe to be the meaning of the text. So your analogy between Marbury Madison and the Emperor's New Clothes is intriguing, and I remember being a first-year law student and pondering the subtle irony of Marshall finding no authority to issue a writ of mandamus, even as he crafted a fundamental rule for the Supreme Court virtually out of thin air. But my question is, if the Supreme Court cannot exercise this role of invalidating legislative acts based on constitutional interpretation, then who would? Rule by legislature is not rule by the people. And so who would implement constitutional protections but for the courts?
Professor Graglia.
Well, unfortunately, there's nobody here for us to turn to and rely on but ourselves. There's nothing here but people. And if the court doesn't make these decisions, yes, the legislature will. Will they make terrible decisions? Yes, but that's, you know, it is not an improvement on democracy. The idea of constitutional law profs being great minds and therefore capable of believing preposterous things that an ordinary person could not, as Orwell said while we're quoting Orwell, there is no alternative to if the court doesn't make public policy, then the Congress does. And our best hope is that we supposedly can make a change in some way, have some effect on congressmen, and we do. But when the court orders busing for racial balance throughout the nation, destroying the public school systems of this country, nothing can or was done. When one federal district court in Kansas City says that the schools of Kansas must spend $2 billion bankrupting Missouri and all other schools to absolutely no good. Did not increase integration, It was done. You know, it makes me wonder, what does it take, 10 billion? 100 billion? When do you say no to a judge? In this country, I don't see when.
All right, let's take another question. Over here.
Thank you very much. I'm a practicing attorney here in Pennsylvania, and I had a question for Judge Sykes and Judge Randolph. Much of what we've heard here today is deeply academic, and I'm wondering how you feel about the trend of selecting our district court and our appellate court judges from the ranks of legal academia and the ranks of what I'll call the active bar, and how that has shaped some of what's going on in the courts today.
I'm just the moderator. Judge Randolph.
Judge Randolph.
I'm not aware there is a trend, is there? That the nominees to the federal judiciary are being drawn from the academia?
Well, what I'm asking is, what is the tendency to pull only from lawyers? Meaning in the 19th century, you had non-lawyers, you had people from the legislature that would come across and become judges. What is the tendency today?
You know, in Philadelphia, this is maybe not totally responsive, but it just occurred to me that I did a study of this and the way that judges were chosen in colonial Philadelphia. It was really interesting. The leader of the bar, the top lawyer, was always, when there was an opening, was always the one that was nominated to become a judge. And I thought, this is really meritocracy. But then I found out the reason for that, and the reason for that was that if the top lawyer had the most clients, and so what you do is you put him on the bench, and the rest of the bar gets to divide his business up. Maybe we ought to go back to that. But I do think I do think that that a mix is a good idea, and we have that on the D.C. circuit. I mean, we have Steve Williams was a professor, and both of these gentlemen, Clark Ford and Harry Edwards, was a professor at Michigan, and then we have people that were practicing lawyers like Brett Kavanaugh and Merrick Garland and so on. So I think a mix is the best way to go.
And I will say that we are, in recent times, seeing more elected state court judges being promoted to the federal bench. I'm an example of that, and I think that brings some necessary diversity as well. Over here.
My question is for Professor Graglia. If, as you said, the Constitution...
Can I interrupt you?
Yes,
it's
sir.
Graglia.
Graglia.
But that
Thank
will
you.
Do. That will do.
An aside, when Justice Scalia and Judge Bork were sitting on the D.C. Circuit, the same thing happened, and an attorney kept saying, "No, Judge Scalia, yes, Judge Scalia." And finally, Judge Bork couldn't stand it any longer. He said, "Counsel, it's not Scalia, it's Scalia." And Judge Scalia said, "Thank you, Judge Bork."
I tell students the name is Graglia, but it's not my duty to teach them to speak Italian. So if they want to phoneticize and anglicize words, they can. But then I point out that I am, B-R-O-G-L-I-O, is pronounced imbroglio, not imbroglio. And all I'm asking them to do then is speak English.
Okay, go ahead.
Thank you.
If you still have courage.
Sure. Professor Graglia,
All right.
if, as you said, the Constitution doesn't exist, it's this flexible, malleable document, and we don't have an objective, unmoving standard by which we govern ourselves, and therefore it's not really possible to establish a Republican form of government, as the Constitution states in Article 4, Section 4, does that mean that our nation was founded on error when it attempted to establish
Yes.
this?
Well, I certainly do not say, I have to say, the premise is wrong. I certainly do not say it's a totally malleable or meaningless or anything like it. No, it has meaning. I was once in a debate with Professor Mark Tushnet, very well known, very liberal, and one of the moderators was Nina Totenberg, the NPR constitutional expert, and she was shocked by what I was saying, as everyone always is, of course. She said, "But Professor Graglia, according to you, nothing's unconstitutional." And I felt like saying, no, that's not my position. My position is nothing's unconstitutional that happens, right? And then she said, "Could you give me an example, if you were on the Supreme Court," I heard a mumble under breath, God forbid, of a law you'd hold unconstitutional, a state law you'd hold unconstitutional. I said, sure, if the states pass a law saying women can't vote, I don't want to pass on the merits of that, but it's unconstitutional. And she felt I had cheated. She said, but no state would pass a law women can't vote. I said, no, they can read. That's why unconstitutional laws don't occur. But as far as the malleable, I believe that Congress, that the legislature should interpret the Constitution, and they can interpret it. It's not really interpretation. They can extend their powers. It's too bad they have to pretend they're exercising the Commerce Clause. The fact is that federalism or divided sovereignty is an oxymoron, and it's better to have a normal government, and we should do things in a mature, honest way. And so I would let the legislature do what it wants, yes.
Professor Nelson, did you have a response to that?
No, let's get more questions.
All right, okay.